Andersen v. Maryland, Supreme Court, 1976. Justice Blackmun delivered the opinion of the court. We must determine whether the particular searches and seizures here were unreasonable and thus violated the prohibition of the Fourth Amendment. 1. In early 1972, a bi-county fraud unit acting under the joint auspices of the state's attorney's offices of Montgomery and Prince George counties, Maryland, began an investigation of real estate settlement activities in the Washington, D.C. area. At the time, petitioner Andersen was an attorney who, as a sole practitioner, specialized in real estate settlements in Montgomery County. During the fraud unit's investigation, his activities came under scrutiny, particularly in connection with a transaction involving Lot 13T in the Potomac Woods subdivision of Montgomery County. The investigation, which included interviews with the purchaser, the mortgage holder, and the other lien holders of Lot 13T, as well as an examination of county land records, disclosed that petitioner, acting as a settlement attorney, had defrauded Standard Young Associates, the purchaser of Lot 13T. Petitioner had represented that the property was free of liens and that, accordingly, no title insurance was necessary, when in fact he knew that there were 2 outstanding liens on the property. In addition, investigators learned that the lien holders, by threatening to foreclose their liens, had forced a halt to the purchaser's construction on the property. When Standard Young had confronted petitioner with this information, he responded by issuing, as an agent of a title insurance company, a title policy guaranteeing clear title to the property. By this action, petitioner also defrauded that insurance company by requiring it to pay the outstanding liens. The investigators, concluding that there was probable cause to believe that petitioner had committed the state crime of false pretenses against Standard Young, applied for warrants to search petitioner's law office and the separate office of Mount Vernon Development Corporation, of which petitioner was incorporator, sole shareholder, resident agent, and director. The application sought permission to search for specified documents pertaining to the sale and conveyance of Lot 13T. A judge of the 6th Judicial Circuit of Montgomery County concluded that there was probable cause and issued the warrants. The searches of 2 offices were conducted simultaneously during daylight hours on October 31, 1972. Petitioner was present during the search of his law office and was free to move about. Counsel for him was present during the latter half of the search. Between 2% and 3% of the files in the office were seized. A single investigator, in the presence of a police officer, conducted the search of Mount Vernon Development Corporation. The search, taking about 4 hours, resulted in a seizure of less than 5% of the corporation's files. Petitioner eventually was charged with the crimes of false pretenses based on his misrepresentation to Standard Young concerning Lot 13T, and with fraudulent misappropriation by a fiduciary based on similar false claims made to 3 home purchasers. Before trial began, petitioner moved to suppress the seized documents. At trial, the state proved its case primarily by public land records and by records provided by the complaining purchasers, lien holders, and the title insurance company. It did introduce into evidence, however, a number of the seized items. 3 documents from the Potomac Woods General file, seized during the search of petitioner's corporation, were admitted. These were notes in the handwriting of an employee who used them to prepare abstracts in the course of his duties as a title searcher and law clerk. The notes concerned deeds of trust affecting the Potomac Woods subdivision and related to the transaction involving Lot 13T. 5 items seized from petitioner's law office were also admitted. 1 contained information relating to the transactions with one of the defrauded homebuyers. The second was a file partially devoted to the Lot 13T transaction. Among the documents were settlement statements, the deed conveying the property to Standard Young Associates, and the original copy of a notice to the buyer about releases of liens. The third item was a file devoted exclusively to Lot 13T. The fourth item consisted of a copy of a deed of trust dated March 27, 1972, from the seller of certain lots in the Potomac Woods subdivision to a lien holder. The fifth item contained drafts of documents and memoranda written in petitioner's handwriting. After a trial by jury, petitioner was found guilty upon 5 counts of false pretenses and 3 counts of fraudulent misappropriation by a fiduciary. He was sentenced to 8 concurrent 2-year prison terms. We turn to petitioner's contention that rights guaranteed him by the Fourth Amendment were violated because the descriptive terms of the search warrants were so broad as to make them impermissible general warrants. The specificity of the search warrants. Although petitioner concedes that the warrants for the most part were models of particularity, he contends that they were rendered fatally general by the addition in each warrant to the exhaustive list of particularly described documents of the phrase, together with other fruits, instrumentalities, and evidence of crime at this time unknown. The quoted language, it is argued, must be read in isolation and with reference to the rest of the long sentence at the end at which it appears. When read properly, petitioner contends, it permits the search for and seizure of any evidence of any crime. General warrants, of course, are prohibited by the Fourth Amendment. The problem posed by the general warrant is not that of intrusion per se, but of a general exploratory rummaging in a person's belongings. The Fourth Amendment addresses the problem by requiring a particular description of the things to be seized. This requirement makes general searches impossible and prevents the seizure of one thing under a warrant describing it. As to what is to be taken, nothing is left to the discretion of the officer executing the warrant. In this case, we agree with the determination of the Court of Special Appeals of Maryland that the challenged phrase must be read as authorizing only the search for and seizure of evidence relating to the crime of false pretenses with respect to Lot 13T. The challenged phrase is not a separate sentence. Instead, it appears in each warrant at the end of a sentence containing a lengthy list of specified and particular items to be seized, all pertaining to Lot 13T. We think it clear from the context that the term crime in the warrant refers only to the crime of false pretenses with respect to the sale of Lot 13T. The other fruits clause is one of a series that follows the colon after the word Maryland. All clauses in the series are limited by what precedes that colon, namely, items pertaining to Lot 13, Block T. The warrants, accordingly, did not authorize the executing officers to conduct a search for evidence of other crimes, but only to search for and seize evidence relevant to the crime of false pretenses and Lot 13T. Petitioner also suggests that the specific list of the documents to be seized constitutes a general warrant. We disagree. Under investigation was a complex real estate scheme whose existence could be proved only by piecing together many bits of evidence. Like a jigsaw puzzle, the whole picture of petitioner's false pretense scheme with respect to Lot 13T could be shown only by placing in the proper place the many pieces of evidence that, taken singly, would show comparatively little. The complexity of an illegal scheme may not be used as a shield to avoid detection when the state has demonstrated probable cause to believe that a crime has been committed and probable cause to believe that evidence of this crime is in the suspect's possession. We recognize that there are grave dangers inherent in executing a warrant authorizing a search and seizure of a person's papers that are not necessarily present in executing a warrant to search for physical objects whose relevance is more easily ascertainable. In searches for papers, it is certain that some innocuous documents will be examined, at least cursorily, in order to determine whether they are, in fact, among those papers authorized to be seized. Similar dangers, of course, are present in executing a warrant for the seizure of telephone conversations. In both kinds of searches, responsible officials, including judicial officials, must take care to assure that they are conducted in a manner that minimizes unwarranted intrusions upon